Can my bank account be garnished without notice? When creditors pursue bank account garnishment, they can legally seize funds to settle outstanding debts, often without prior notice. This sudden freeze on your account can significantly disrupt your financial stability, potentially jeopardizing your ability to pay for essential living expenses. However, it's important to know that certain funds are exempt from garnishment under state and federal laws, such as Social Security or unemployment benefits. Understanding these exemptions can help protect you from undue hardship. Law and legalities of bank account garnishment in New Jersey. Bank account garnishment is a legal process that allows creditors to collect debts through a court-ordered writ of execution. A creditor must first obtain a court judgment before proceeding. Once a writ is issued, a sheriff or court officer freezes the debtor's account. However, the debtor is not initially notified about the levy. Notification typically comes when the creditor files a motion for turnover of funds, at which point the debtor can object. State laws in New Jersey stipulate that no funds can be turned over to the creditor until at least 20 days after the levy. During this time, the debtor can contest the garnishment, especially if funds are exempt or procedural errors occurred. Immediate garnishment without notice may occur in cases involving child support, alimony, or tax debts. How bank account garnishment works. When a creditor initiates a bank levy, the process begins with the court issuing a writ of execution. This allows the creditor to freeze funds in the debtor's bank account. Following the freeze, the creditor files a motion for turnover of funds to access the seized funds. Debtors are then notified of this motion and have the opportunity to file an objection within the mandatory 20-day window. If the court upholds the debtor's objection, funds will be released. If not, the creditor gains access to the frozen account funds to satisfy the debt. Steps you can take to protect your assets include monitoring your accounts for suspicious activity, maintaining separate accounts for exempt funds, and promptly responding to any levy notifications. Working with an experienced attorney or law firm during this process is crucial to understanding your rights and options. Contesting a bank account garnishment. Contesting a bank levy involves a multi-step process. First, upon receiving notice, review the source of the frozen funds to determine if they are exempt, such as Social Security or unemployment benefits. File a formal objection with the court, including supporting documentation like bank statements. Next, serve copies of your objection to all involved parties, including the creditor, bank, and sheriff. Finally, attend the court hearing prepared to demonstrate why the funds should not be garnished. A favorable ruling can result in the release of funds back to your account. Straffi Straffi Attorneys at Law can provide invaluable assistance during this process, ensuring that your objection is properly filed and arguing on your behalf during hearings. With extensive experience in bankruptcy and debt-related matters, their team works diligently to protect clients' rights and finances. If you're facing a bank account garnishment or want to better understand your legal protections, contact Straffi Straffi Attorneys at Law at 732-341-3800 or visit their office at 670 Commons Way, Toms River, New Jersey, 08755. Their dedicated team is ready to help safeguard your financial future.